Hi friends, welcome back. Indian Constitution, President Chapter Part 2 by PRAVEEN JAYARAMAIAH by Joy Civil Service Academy. As in our previous video, we have completed Part 1 of President Chapter and the remaining topics are covered in this Part 2 video of the President Chapter Indian Constitution. Term of President's Office. President holds the office for 5 years from the date on which he enters upon his office. He can resign from his office at any time by addressing the resignation letter to the Vice President. President can be removed by impeachment process. Can also hold the office beyond his term, that is 5 years, until his successor assumes charge. Eligible for re-election and can be elected as any number of times. Unlike USA, a person cannot be elected to office of the president more than twice. In India, a president can remain in his office for 5 years. His term of office is 5 years, and he can resign at any time by addressing the resignation letter to the vice president. President can resign from his office by addressing the resignation letter to the vice president only. President can also be removed by impeachment. We will see the impeachment process in our next slide. And he can also hold his office beyond the 5 years term until his successor assumes the charges. For example, if a president 5 year tenure is completed and there is a delay in the new election for the new president, until then the previous president shall remain in the office of the president until his successor assumes the charge. And also in India, there is no condition like USA that a person can be elected as a president only twice. Nothing is there in India. Only in USA, a person cannot be now elected to the office of the president more than twice. In India, there is no such condition. A person can be elected as a president for any number of times. Impeachment of President. President can be impeached for violation of the Constitution. President of India can be impeached for the violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. See, the Constitution itself does not define the meaning of the phrase violation of the Constitution, on which the basis of the impeachment process is going to take place. In our Constitution, violation of the Constitution phrase is not being defined of that meaning. The meaning is not defined. The phrase violation of the Constitution. On that basis only, President is impeached. Impeachment charges can be initiated by either house of parliament, that is Rajya Sabha and Lok Sabha. Here, no provision for the state legislature to get into this impeachment charges. Only parliament, that is Rajya Sabha and Lok Sabha, only can initiate the impeachment charges. These charges should be signed by one-fourth member of the house. If a Rajya Sabha is initiated the impeachment charges, then the one-fourth member of the house should sign these impeachment charges. Then only it is considered. 14 days notice to the president. 14 days notice should be given to the president regarding this impeachment process. Impeachment process is passed by two-thirds of total membership of the house. Then the bill will be sent to other house. If the Rajya Sabha first initiated these charges, it has to pass this by two-thirds of the total membership of the house. Then only it will be passed to the other house, that is Lok Sabha. Other house will investigate the charges. Here the other house is, as we have considered the example where Rajya Sabha initiated the charges of impeachment and it has passed by the two-third majority. Now it is in Lok Sabha, these charges will be investigated, and again if it is passed by two-third of the total strength, and again then the president shall stand removed from his office from the date on which the resolution is passed. President has right to appear and to be represented at such investigation. It is also known as a quasi-judicial procedure of the parliament. The impeachment process of the parliament is known as quasi-judicial procedure. Who can vote for removal of the president? Elected members of Rajya Sabha and Lok Sabha, nominated members of Rajya Sabha and Lok Sabha. Who cannot vote for the removal of the president is MLAs of all states, including union territories of Delhi and Puducherry, cannot vote for removal of the president. Even though they can vote for the election of the president, they cannot vote for the removal of the president. Even in case of nominated members of Rajya Sabha and Lok Sabha, they cannot vote for the election of the president, but they can vote for the removal of the president. And one more important thing to remember, no president is so far impeached in India. Vacancy, expiry of his tenure, resignation, impeachment, death, office of profit. Expiry of tenure. When vacancy is caused by expiration of term 5 years of sitting president, election to be held before expiration of the term. In case of delay, outgoing president continues to hold office until his successor assumes charge. In such cases, vice president does not get chances to be the president. When there is an expiry of the tenure, the 5 years tenure of a sitting president gets expired and the election to be held before the expiration of the term. In case there is a delay, the outgoing president shall continue to hold the office until his successor assumes the charge. In such cases, vice president does not get any chance to be the president. By resignation, impeachment, or death, in these three cases, vice president can act as a president until new president is elected. Election should be held within 6 months, and newly elected president remains in office for 5 years. And if vice president is absent, Chief Justice of India or senior most judge of the Supreme Court can act as a president. Anyone acting as president need to take the oath and also enjoy all the power and immunities of the president. Election should be held within 6 months. Newly elected president remain in office for 5 years means if a president dies at the office after completing 2 years, and the newly elected president shall remain in office for 5 years and not for the remaining years for the 3 years. Very important that new president elected for the office shall be continue to be in the office for 5 years, not for the remaining 3 or 2 years. Powers and functions of president: executive power, legislative power, financial power, judicial power, diplomatic power, military power, emergency powers. Executive powers are: all executive actions of the Government of India are formally taken in his name. Prime Minister and other ministers are appointed by President. They hold office during his pleasure. Also appoints Attorney General of India and hold office during his pleasure. Appoints Comptroller Auditor of General, Chief Election Commissioner, UPSC Chairman and all members of Finance Commission and so on. Also appoints the Interstate Council to promote interstate and interstate cooperation. Legislative pass. President can summon or prorogue parliament and dissolve the Lok Sabha and also can summon joint sitting of both the houses. He can address parliament at commencement of first session of each general election and first session of each year. He can appoint any member of Lok Sabha to preside over his proceeding when office of both Speaker and Deputy Speaker falls vacant. Similarly, in Rajya Sabha also, President can appoint any member of Rajya Sabha to preside over its proceeding when the office of both chairman and deputy chairman falls vacant. He can promulgate ordinance when parliament is not in session, but it must be approved within 6 weeks from its reassembly, and also it can be withdrawn by him at any time. Financial powers. Money bill can be introduced in parliament only with prior recommendation. No demand for grant can be made except on his recommendation. He can make advances out of contingency fund of India to meet any unforeseen expenditure. He constitute a financial commission after each 5 years to recommend the distribution of revenues between center and state. Judicial power. President appoints the Chief Justice of India and judges of Supreme Court and High Court. President can seek advice from Supreme Court on any question of law or fact. The advice is not binding on the President. Diplomatic powers, international treaties and agreements are negotiated and concluded on behalf of the President. He represents India in international forums and affairs and send and receive diplomats like ambassadors and high commissioners, etc. Military powers. He is the Supreme Commander of Defence Force of India. President appoints Chief of Army, Navy and Air Force. He can declare war and conclude peace subjected to approval of the Parliament. Emergency powers. There are three types. National Emergency Article 352, President's Rule Article 356 and 365, Financial Emergency Article 360, Veto Power of President. Bill passed by Parliament can become act only if it receives assent of the President. When such bill is presented to the President, he has three alternatives: whether to give his assent, withhold assent, return the bill for reconsideration. He cannot return the money bill if the bill passed again with or without amendment. President must give his assent. Types of veto power: absolute veto, qualified veto, suspensive veto, pocket veto. In India, qualified veto is not there as it requires two-third majority. Suspensive veto requires only simple majority. And when it comes to the absolute veto, power of the president to withhold his assent, bill then ends and does not become an act is known as absolute veto. That veto can be seen in private members' bill. A member who is not a minister is known as private members' bill. Government bill when the cabinet itself resigns. Suspensive veto returns the bill for reconsideration of the parliament. If that return bill is passed again by the parliament with or without amendment, president has to give his assent. If and also president cannot return the money bill, he can only give his assent or withhold. Pocket veto, neither ratify nor reject nor return the bill, keeps the bill pending for the indefinite time. No action will be taken. For pocket veto, no time limit is specified. Unlike in USA, it has a 10 days time limit specified. President veto over state legislature. A bill passed by state legislature can become act only if it receives assent by governor or president if reserved by governor. A bill passed by state legislature to the governor has four alternatives: whether to give his assent, withhold, return the bill, or reserve for the president. And even president has three alternatives: whether to give his assent or withhold, ask the governor to return the bill. If passed again by the state legislature, president is not bound to give his assent. In case if it is in parliament, president has to sign the bill which has been passed again by the parliament. In case of state legislature, it is not there. President can reject the bill even if it is passed by the state legislature again. Ordinance making power. Article 123 promulgate ordinance during recess of Parliament. It has same force and effect as that of Act of Parliament. In case of urgent matters, only when both the houses of Parliament is not in session or either of two houses of the Parliament is not in session, it can only make laws on the subject on which Parliament also can make. Judicial review is also there for the ordinance. 44th Constitutional Amendment Act. It cannot abridge or take away any fundamental right and also cannot amend the constitution. If the both the houses approves the ordinance, then only it can become an act. Ordinance cease to operate if both the houses of has passed a resolution for disapproving it, or even president can withdraw at any time. No action by parliament cease to operate on expiry of 6 weeks from reassembly. Maximum life is 6 months and 6 weeks in case not approved or considered by the parliament. Ordinance is not a discretionary power, as he can withdraw ordinance or promulgate only on the advice of the Council of Ministers headed by Prime Minister. Ordinance can be retrospective. Pardoning power. Article 72 empowers the President to grant pardon, removes both sentences, conviction, and completely absolve the convict for all sentences, punishment, and disqualifications. Commutation. Substitute of one form of punishment for a lighter form. Example, death punishment to rigorous imprisonment. Remission, reducing the period of sentence without changing its character. A rigorous imprisonment for 2 years may be remitted to the rigorous imprisonment for 1 year. This is known as remission. And respite, lesser sentence in place of original due to the special facts, physically disability or pregnancy of women. Reprieve, stay of the execution of sentence for a temporary period, is known as reprieve. Examination by Supreme Court. Petitioner for mercy has no right to oral hearing of the by the President. He can examine the case fresh and take different view. Power can be exercised by President on advice of Union Cabinet. It is not bound to give reason for his order. President is not bound to give reason for his order. No need for Supreme Court to lay down specific guidelines, not subjected to judicial review except when President decision is modified. Discretion power. President has no constitutional but only situational power. President has no discretional power mentioned in the constitution, but he has only situational power, like appointment of prime minister when no party has clear majority in Lok Sabha, or when prime minister in office dies suddenly and there is no obvious successor. In dismissal of Council of Ministers when cannot prove confidence in Lok Sabha, dissolution of Lok Sabha if Council of Ministers has lost majority. Thank you. Please like, share, and subscribe our channel.